And basically it was assault. And so the Starbucks was included in a lawsuit, and Starbucks argued that they're not responsible because the employee was not acting within the scope of their duties. And the district court held that Starbucks was not liable because its employees were not acting within the scope of their employment when they injured the plaintiff. So it was after hours, it was outside, it wasn't actually while they were still in the store that they got into the assault part of the altercation. So in this situation, the business could have been, what if it would have happened inside of the store, the altercation? That may have changed things a little bit, even though the employee is not authorized to do that. What if that person was being unreasonable and wouldn't leave the store? At that point, and security escorted them out. Let's say it was a place where there was a security, and security escorted them out and they got in an altercation then. That could be potentially liability for the business. So you have to be very careful when you have a business on what kinds of things you're allowing to happen in your place of business, and what your employees are, what your employees think that they're authorized to do. So it's the critical legal thinking questions here that require employers held liable for the torts committed by employees when they are acting within the scope of their employment. And it's difficult to determine when an employee is acting within the scope of their employment and when they're not. So first of all, employers are not held liable, or they are held liable if they're acting within the scope of their employment because they're doing what they're supposed to do according to the business. And second of all, it can be difficult. It shouldn't be too difficult if you outline their duties and their responsibilities. But if there's not clear cut instruction on how to handle certain situations, then it could become a little muddy on if it was the liability of the business or if it's the liability of the person and they were acting on their own. So there are three main types of agencies that are created between a principal and an agent. So the principal being the owner, the agent being the person acting on behalf of the owner. An express agency is formed when the principal expressly gives the agent authority. So if I said, I allow you to enter into a contract to purchase additional food at any point in time, then I've given you express agency. An implied agency is formed when the authority is applied by the conduct or the duties. So if I hired you and your hiring package, the duties outlined that you were responsible for purchasing food for the restaurant, then it's implied that you are an agent and you contract on behalf of the business. And then a parent agency is formed when the principal believes a third party to believe the agent has the authority. So I wanted to tell you a little story about a situation that happened to someone I know. They were working for a company and they were responsible for the phones in the company. And the phone service that they had was a great phone service, and they didn't have a contract phone service, so they went ahead and they reached out and they found a contracting company or a phone company that would contract with them for a 5-year stint, and it would be a really super good package, and it was very, very desirable and a great cost. And so that person, even though it was their duty to do that, they went ahead and checked with the owner, and they emailed the owner and said, hey, this is the information, this is what we have going on, this is a contract, do you want me to proceed? And the owner said, yes, take care of it. So that person went ahead and signed the contract for the business and secured the phone system for that business. Well, a few years later, that person was no longer working for the business, and the business owner decided they wanted to move. They were going to move the business to a different location. And in the contract, it states that the 5-year contract, it was 5 years, stated that the phone equipment could not be moved without a fee or new setup or whatever it be. So the business owner said, you know what, I don't care, I'm just going to cancel the phone service, I'm done. And the phone service company went ahead and sued the business owner. The business owner then brought suit against the employee, former employee at that point, for entering into a contract on behalf of the business without having the authorization to do so. So how do you think that went?
Horrible. That's
horrible. So that lawsuit for the employee obviously didn't go anywhere because it was a frivolous lawsuit, meaning that it had basis. And the reason it had basis is that employee actually kept all their emails. So they had proof that the business owner said, go ahead and do it. So what type of agency was formed in this situation? There's actually two. Anybody know? It was an applied agency because that person's, the employee's duties, responsibilities were actually dictated that said that they were to secure the phone system and maintain it. And then the express agency was created when that employee asked for permission and the business owner gave them permission. And it was done by email, which in business is really great to have that written documentation. So it didn't come from the business owner, but it worked out to their employee or their former employee. So how many of you know what an independent contractor is? I mean, I can't see hands. Most of you have it all. Okay, thank you, Vanessa. Thank you, Vanessa. So an independent contractor is a person that a person or business that provides a service for another business. So but you're not an employee. You're not hired as an employee. You're just doing it for your own business or as your own person. So, for example, a lot of cleaning crews are independent contractors, and they go around to businesses and they provide the service of cleaning the offices at night or whatever it may be. Event coordinators are independent contractors, and they're the ones that pull the whole event together and they work the business, but they don't actually get employed with the business. A lot of group professionals, such as doctors, dentists, CAs. Have you ever been to, I'm sure everybody's been to a doctor's office or dentist's office before, but when you go, a lot of times you'll see that there are several different dentists or several different, it happens a lot in dentists, but several different doctors in the same building. And all of them may be independent contractors, and they're not actually employed by that business, but their services are provided by that business. There are times that a business owner may need that independent contractor. It may need something very specific that they need, and they may need them to act on their behalf. They may need them to go and enter into a contract for them. So, for example, a real estate agent A lot of times, a real estate agent becomes an agent, as their name says, for the business if the business is looking for property or a new site to lease or whatever it might be. And that agent is allowed to enter into or draft up, get that contract they're allowed to say, this person wants this and this person wants this now or whatever. So they're allowed to say that, they're allowed to act on them and supposed to have. So who do you think is responsible for the decisions that are made when an agent is acting on the people's behalf? The principle is, right? They've been given, the agent's been given the authority to act on that person's behalf. And so that principal is going to be liable for whatever decisions they make. There are several instances of tort liability for principals and agents, and the scope of the agent's employment is evaluated to find out who is liable. So let's take a look at case 25.1. That is on page 478 in my book.
446.
Thank you. And I'm going to give you guys a minute to read this, and we'll talk about it.
I'm sorry, what was the case name?
It is
446.
Okay, so Matthews versus Food Line?
yes, correct.
Yes.
Thank you. So what respondent superior mean? Respondent superior.
That is a legal term that I am not familiar with, but I would look up for you.
It's actually right above the case.
Oh, okay, yeah, you're right. I'm sorry. I was thinking you said something else. So that is a rule that says an employer is liable for the courteous conduct of its employees or agents while they are acting within the scope of the employer's authority.
I don't see an employee take home. She did not knock on the door, did she?
I know, it wasn't very clear, was it?
No.
It's like when they found them laying on the floor. No, they actually knocked on the door. So she was going in this case, or she or whatever was going in. Yeah, she was going in at a brisk pace, and upon opening the door, discovered that person on the floor. So most likely them with the door and knocked them out or whatever.
Well, that was not far.
there are other, just since you said that about her being off the clock, so there are some, this situation, I'm not exactly sure, obviously, what happened with it, but, and it is pretty vague. But her being off the clock, some employers recognize that, and some employers don't recognize you being completely off the clock until you've left property.
Tell your own premises.
So yeah, so in this case, it was off the clock was what they judged as being you're no longer working. Where there are some places that have more liability because until you leave the premises, you're not completely off clock. And that has to do also with because it's a result of salary employees that don't actually punch the clock. You know, they are there for whatever reasons, for how long or whatever. So that's part of the reason that is a thing for some businesses. So do you guys think that Food Lion should have denied liability in this case?
I think so.
Yeah, I mean, they don't really have the liability, but on the other hand, she was still in their building, right? And was this a close case to decide? I'm pretty sure it was, like we just talked about. It's kind of the, you know, was she completely off the clock? Was she not? And did any party act unethically in this case? Well, I mean, you guys can answer if you like, but I think that not necessarily unethically, but, and I understand you get off work and you just want to rush out and you want to be done with it, right? So, and maybe she was really in need of the bathroom break. So she went at a brisk pace, and maybe it was just something that she needed to be a little more cognizant of her surroundings, and she should have just slowed down a little, and that wouldn't have happened. But of course, looking at it from our point of view on this side of things, it's a lot easier to say that than it is, you know, to act that. And everybody has a situation where they may have not have acted the way that they feel like, or that others feel like they should have. So. All right. So we've talked about tort liability a lot, and the tort liability for principals and agents to third parties. When there's negligence, the agent is liable, and the principal is liable under the doctrine of what we just talked about, respondeat superior, if the agent's negligent act was committed within his or her scope of employment. If there's an intentional tort, which is, you know, assault, battery, false imprisonment, those types of things. If that happens, then yes, the agent is liable. There would be a motivation test given, and the principal is liable if the agent's motivation in committing the intentional tort was to promote the principal's business. So if we look back at that case and, you know, we look at the business to see if they were liable, then you could say, well, the business wasn't saying she had to rush to the bathroom and fling the door open so quickly, you know, so that was not in the business's best interest anyway. And so that might have played a part in that case as well. And if there's an intentional tort, they also could do a work-related test, which is where the principal is liable if the agent committed the intentional tort within a work-related time and space. Notice it says space and space. So like I said, some businesses that is more clear than others. And then misrepresentation. So if misrepresentation is done by an agent, then yes, the agent is liable, and the principal is liable for the intentional and innocent misrepresentations made by an agent acting within the scope of his or her authority. So if they didn't know that they were misrepresenting, it was an honest mistake, then it's very, very likely that the principal would be liable as well. Let's take a look at.
Sometimes laws make you not want to be helpful.
Well, laws are if this, then that, and there's always something. And something to be said about laws, and this goes for on a smaller scale, policies and procedures in a business too, is that if they get to be really specific, they can actually do more harm than good. So you have to there's a really fine line with law and with how it's presented. In fact, I was going to talk about this possibly later on, but you all know that there is disaster assistance out there right now for the Paycheck Protection programs out there for small businesses. They can have this grant. They can apply for this grant and get money to help pay for their workers so that they can retain their workers. Well, and we're going to talk about business structures a little later on. And one of the business structures that we'll talk about is an LLC. And in an LLC, or a limited liability company, there are different ways that they can be taxed. So they can be taxed by, just like an entrepreneur on their own tax return, like a partnership on K-1s, or they can be taxed as an S Corp if they are designated as an S Corp. And we'll talk about all these later. But if they're taxed as an S Corp, they still receive a K-1, similar to if they were a partnership. But in this Paycheck Protection Program, if you are an S Corp elected LLC, you aren't eligible for as much money as you are if you are an LLC that is designated as a single member or designated differently. So that is all about what's written. It's written in such a way that those K-1s that the S Corp LLCs have don't actually apply for owner's compensation. So it's very much in the way you write it and in the way you drill down into those details. And it's the same thing in law. So let's look at case 25.2. This is Berlarli versus Walmart Stores, Inc. In my book, it's 480.
Or 48.
Thank you. Have you guys ever had that happen?
No.
Yeah,
That would be quite quite an experience, right? I don't know what I would do if a cashier started throwing groceries at me.
I would have thrown the bag straight back.
Then you'd
Yeah.
probably get sued.
No kidding, huh? So this case, what do you think they use to, or does it say? It actually says, okay, so never mind. I'm not going to ask the question. I'm just going to tell you. So they applied the motivation test, and we talked about that a little bit before. So the principal is liable if the agent's motivation in committing the intentional tort was to promote the principal's business. So in this case, they're not off the clock. They're just acting crazy, right? Throwing groceries at people, trying to make their shift go faster because they're unhappy with their job or whatever. But by applying the motivation test, is it in the business's best interest for that cashier to be throwing groceries at people?
No.
No. So, so that's what they did. They applied the motivation test, and they held that Walmart was not liable for the intentional tort of its cashier. So at that point, the what's his name, Berlarley, would have to file suit against the employee in particular. And of course, we talked about this before. Why would you want to sue Walmart as opposed to that employee? Most likely you would get a better settlement from it, right? So do you think it was ethical for Walmart to deny liability for its employees' actions in this case?
yes.
No.
Yeah. You think it was ethical? I got a yes and a no.
That was a yes for me. I just don't see how you could monitor what everyone's doing. You know, it's not really their fault that someone decided to act like a jackass at work.
Was that what you were going to say too, Rihanna?
Yeah, I mean, you just can't control everybody, you know, it's not their fault.
Yeah, so I mean, they're going to deny, right? But do you think that right after that, they wrote up some employee policy that said you will not do this and had all their employees sign it?
Mhm.
Yeah, most likely they did, right? If the court applied the work-related test, would the outcome of the case be different? So now remember, the work-related test is that the principal is liable if the agent committed the intentional tort within a work-related time and space.
Mhm.
So they would have been. So depending on the test, when there's an intentional tort that has been committed, depending on the test, that's where it gets a little crazy on how it's decided. So, and you know, I think it would depend on a lot of things. A lot of the situation was probably, you know, they looked at it and went, oh, this is crazy what this cashier was doing. So we need to look at it from this perspective. So, going back to my story about my friend that that was sued because they had entered into that contract for the phones for the 5 years on behalf of the business owner. Do you think that if it had been that they entered into that contract a year after they left, do you think that would have been the same outcome for the lawsuit?
No.
No, because they no longer were an agent of that business. So agencies between a principal and an agent can actually terminate, and they can terminate in different ways. So you want that responsibility to end, right? I don't want to be responsible for a business I don't work at anymore. I don't think anybody wants that responsibility. So an agency is terminated by several actions: an act of the parties, so, you know, termination, an unusual change in circumstances, impossibility of performance, and operation of law. So what acts of the party, we talked about this a little bit. So the acts of the party that would terminate an agency would be like mutual assent. Okay, so you know what? I don't feel comfortable entering into contracts for you anymore. And the principal says, yes, I agree. We should just not do that. So you should come to me and I'll enter into the contracts myself. Or I'm no longer an employee. I've quit. So now I don't want to, I don't want that responsibility anymore. So what agency terminating items do you think would fall under impossibility of performance? So what happens if I work in a position where, what happens if I work in a position where I am on, I work for a company, and for my job, I have to be certified. So for example, here, I'm a teacher and I have to be certified, but this isn't a good. Okay, let's think of a doctor. So a doctor is a doctor, right? But if they don't keep up with their continuing education, if they don't keep up with their if they have a lawsuit against them and they lose their right to be a doctor, if they lose their license. Yeah, sorry, my head is crazy today, but if they were to lose that, then all of a sudden they are no longer eligible for that role, right? So in that case, that agency would be terminated. So let's say that I have a certificate in, let's see, what can I think of? Oh, I got a good one actually. So let's say that I'm the manager of a restaurant. We'll go back to my restaurant. I'm the manager of the restaurant and I have my food handler's permit and it expires. I'm no longer eligible for a lot of things in a restaurant. When you don't have your food handler's permit, you can't do much of anything in a restaurant, right?
Mm-hmm.
So, the point is that the agency can be terminated. So let's, okay, I'm gonna skip this. I was gonna have us look at another case, but I think I'll skip this and we'll come back to it if we have time because we're getting there. So chapter 26 talks about small businesses, entrepreneurships, and partnerships. So I was telling you before that we were going to talk about the structure of a business. And in this chapter, we'll go over that. And actually the next few chapters will go over the structures, the different structures of businesses. So an entrepreneur is a business owner and operator. So there are several considerations that must be made when you're creating a business. And one of those things is what form. So what is your structure? And the main business forms are sole proprietorship, which a lot of times you'll hear me refer to as sole prop. I apologize. That's just what I do. General partnership, limited partnership, limited liability partnership, limited liability company, and corporation. So those are the major forms of business. So we will discuss each of those in greater detail over the next next couple of classes. So this class and next class, there's some stuff in it too. The form of the business that is chosen will dictate the process for becoming a business. In the state of Arizona, if you're forming a partnership, you would file with the Arizona Secretary of State to become a partnership. If you were forming an LLC or a corporation, you would file with the Arizona Corporation Commission. So it's different here. There are other states where all of them are formed under the Secretary of State or under the Corporation Commission or whatever. So it just depends. But in our state, we have two different places that you can go depending on what business you are forming. You may have to obtain permits and licensing in order to operate, depending on what kind of business you are going to be doing. Excuse me. The simplest form of business is a sole proprietorship. It is the most common small business. And in this, there's a single owner and they control the business and they have rights to all the profits of the business. It is really simple to form a sole proprietorship, and it is, in fact, the default. So if no other business form is selected, then you are a sole proprietorship. However, it's also the riskiest type of business. The owner and their assets are not protected in any way. So if someone sues the business, then they can take all that the business owns as well as anything that the owner owns. Also, because the business is not a separate entity, it is taxed on the owner's personal return. So when I was talking to you earlier about that PPP program, these owners, they file a Schedule C. A sole proprietorship, they file a Schedule C. So in their tax form, tax return, we all file our 1040 or our 1040 EZ or whatever it is, right? So they form an additional schedule in the 1040 that's called a Schedule C, and it talks about the business and what it does. And all that taxing from all the business revenue goes to the individual. And so they're taxed on it. So a lot of times, depending on the individual and how much they've made and all of that, those types of businesses have a higher tax. They're probably not receiving a tax return. They're probably having to pay taxes, right? So it's very possible. Let's look at case 26.1, which is Bank of America versus Barr, and this talks about a sole proprietorship, and this is on page 492 in my book.
460.
Thank you. I'll give you a
Quick
few
question.
minutes to read it.
If you are a sole proprietor, can you change your business to an LLC, or once you're established, you're established?
No, you can change at any time. You can
Okay.
take your business to a different type of business at any time.
Okay.
Well, within reason. Corporations are a little more more difficult for that kind of thing, but I mean, it can be done.
Okay.
You may have to close the business and reopen it as the other entity, but you can do it. So why do you think sole proprietors are personally liable for the debts of their business?
Because there's no one else to blame.
Yeah, they used their own finances most likely to start the business. They're not protected in any way. And they're the ones that are paying the taxes and everything for the business. So there's not really any protection there. Did Barr act ethically in denying responsibility for the Stone Scones debt?
No.
No, I'm hearing all no's, no yeses today. No, I don't think she did either. I think that, I mean, you were the one that said, okay, I'm going to take on this debt and you're responsible for it. So the next thing is partnerships. So when two or more people get together to start a business, they may decide to form a partnership. A general partnership is the most common type of partnership. And in a general partnership, all the general partners are personally liable, similar to a sole proprietor.
Going back to that case, so say she didn't have the money to pay it back. Do they go after her assets? Is that what it is? Like her home, whatever she may have, that's the value?
Yes. Yep. And I mean, they would take her to court, they would sue, whatever. The judge would say, okay, here's the valuation of your assets, here's the valuation of everything, and then it would be decided how to make amends for all that. Most likely she would be, if she didn't pay that off, she'd have to sell off some assets, and she'd probably have to pay, with a possibility of even having her wages garnished in order to get those payments back, so that was taken care of. So entering into any kind of debt is a very huge thing on an individual basis as well as in a business. So you really have to be cognizant of what you're agreeing to. And if it's not something you can handle, you shouldn't take it on. Now, she could seek bankruptcy. Remember, we talked about bankruptcy. She could file for bankruptcy, and in that case, then Bank of America wouldn't necessarily have much of a leg to stand on. So that's something that is possible in those kinds of cases as well. So it's risky on both ends. Bank of America took a huge risk by giving her money, or allowing her to take a loan from them. And that's why loans aren't exactly the easiest thing for most of the time. So in the partnership, in a general partnership, all general partners are personally liable, and the taxation of the partnership is known as flow-through taxation. So basically, a business tax return is filed, and the partners all receive a form that shows their share of the profits. So that's the Schedule K-1 that I was talking about before. And then they're taxed. So the partnership, the business itself is not taxed on the revenue, but the partners are taxed for their share of the revenue. So depending on what share they hold in the business is what they would be taxed, or what percentage they would be taxed. And most of the time, it's an equal share unless it's otherwise stated. Limited partnerships are formed when the business has both general partners and limited partners. A limited partner is one who has invested in the business but does not does not participate in the management of the business. So they don't do anything beyond giving the money for the business. So let's say that my brother and I decide to go into business, and my brother says, okay, well, I don't want to run this business. I want you to run the business, and I'm going to put in this much capital. And so then he would be the limited partner, and I would be the general partner in that situation. Limited partners, so he'd have the better end of the deal as far as protection is concerned, because limited partners are protected from liability up to the amount of their capital contribution. So let's say he put in $100,000. If we got sued, he could get sued up to the $100,000, but no more. they couldn't touch his personal assets at that point. So I could be sued for everything. So whatever I have, my house, my car, whatever. So when a partner that's acting on a partnership business enters into the contract, all the partners have unlimited personal liability for that contract. So as partners, you're all agents of the business. So you can enter into those contracts and every other partner is responsible for whatever your decision was. So how important do you think it is to get partners that you trust and get a good system for entering into contracts?
Communication is key.
For sure. And there may be something written into their partnership agreement that says that any decisions about contracts have to be a majority before they can be entered into. So, you know, let's say there's 4 partners, then 3 of those partners have to say yes before they can actually do that. The majority has to rule there.
So if it's a tie, then it's a no-go, right?
Then at that point, yeah, they would need a tiebreaker. And so, you know, that could be, they could have that established as well. They could say, well, our tiebreaker is this. And, you know, so, you know, everybody stands on their head and whoever can do it the longest is the one that wins. No, I'm just kidding. So
Flip a coin.
that's right. So no, they might have a tiebreaker in those cases, which is maybe an outside party that comes in and gives their opinion. And then they base it off of that or something, but they may write that into the partnership agreement. A tort that is committed while a partner is acting on partnership business would also make all the partners liable for that tort. A partner who has been made liable for a contract that they didn't enter into or a tort that they did not commit could seek and I can never say this word, indemnification from the partner who did. And I'm struggling today. So basically they can seek, they can go after that partner. So if a partner commits a tort and the other ones get sued for it, they can actually come after the partner that committed the tort. So that's something to think about there. So chapter 27 starts talking about corporate formation and financing. So we're going to get into the corporations. Corporations are a form of business that is created as a separate legal entity. So do you guys all understand what I say when I say entity, what that is? So each one of us is an entity. I'm an entity, Vanessa's an entity, Erin's an entity, and so on and so forth. We're all entities. So a corporation is its own entity. So it's its own thing. When you are a sole proprietor, you are the entity. So if I have a sole proprietorship, I have the entity, I am the entity. So that is my business, I'm the entity. But when you have a corporation, the corporation itself is the entity, and everyone that is involved in that corporation, everyone that has shares or owns stock in that corporation is just a stockholder. Corporations have unlimited owners, so you can have as many as you want, and some of the larger corporations have thousands upon thousands of shareholders. And a corporation is liable for its own obligations. So if someone sued, they would sue the corporation. So in the case of Walmart, they were suing Walmart and not the owner of Walmart, right? The shareholders are only liable to the extent of their contributed capital. So it's kind of like a limited partner, right? So if they put in $100,000, then they're only liable for that $100,000. So if the business doesn't have enough money to pay that $100,000 that they're sued for, then they can come after those shareholders for up to their capital contribution.
Does it matter if it's a common shareholder or a, can't think
Preferred?
of the other, yeah, preferred, thank you.
Yep. We'll talk about that a little bit, but
Okay.
there is some stuff in there, but let me get through this part and then we'll talk about common and preferred stock and how that works.
Okay.
So let's look at case 27.1, and this is Mendez versus O'Neill. It is on page 512 in my book.
480.
Thank you.
What's to stop Savoy from suing the corporation instead of the sole shareholder? Would the corporation be liable?
That's a very good question. So the corporation is what they're actually suing. So they're suing Triumvirate Corporation or whatever that's called, but they were also suing him as well. So a lot of times what happens in a lawsuit is the person suing is going to go after everyone they can think of. They're just going to say boom, 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 boom. So because he was a sole shareholder, they went ahead and put his name on there as well. And he said, wait, you've already got my corporation on there. You don't need me on there as well. This happens a lot, and I can tell you there was a lawsuit for the appraisal company that I was working for. I think we talked about this a little bit before, but the lawsuit was because some homeowners were upset that they were not told that there was going to be a major road put in very close to their new construction home. And it actually was in there, and the appraiser did mention it, so it didn't go anywhere from the appraiser standpoint, but the builder had a right to tell them, and the builder was on there, the appraiser was on there, the real estate agents were on there, everyone you can think of that's involved, the banks were on there, everyone that you can think of that was involved in the sale of that house, of those houses, was on the lawsuit. And half of those people got taken off the lawsuit because it was frivolous. It was something that they shouldn't have been sued for. Like the appraisers in this case were not liable because they had disclosed that there was a proposed road that was going to go in next to their home. And just because someone didn't read the appraisal doesn't mean that they should be sued for something, right? So, but you know, it ultimately came back to the builder. and the builder was the sole suit at that point. They were the ones that were actually the only ones left on the suit because they were the ones that had dropped the ball or whatever. So
Just a little side question on that, Cindy.
okay.
The appraiser wasn't liable to disclose that information in his report. I mean, or wouldn't that be like due diligence on the buyer and builder's part?
It absolutely, it would be,
Okay.
the builder number one, they should have disclosed that. If they were aware that something was going in, they should have disclosed that.
If they
The buyer, what was that?
if they were aware.
If they
Yeah.
were aware, yes. And the buyer should have done their due diligence. They should have looked and said, what's going on? They should have read their appraisal report. And yes, the appraiser didn't have to put that, but the rules for appraisers, so I actually was very fortunate. I worked at a really awesome appraisal company, and they were very thorough. So when that big housing crisis hit in 2007, 2009 area that we've talked about several times, I was working for them then, and their appraisals were basically bulletproof. They had done so much work on these appraisals and solidified it so well that our business, the only thing that got caught up in this whole thing was the fees that were charged, because a lot of crazy stuff was happening, and then banks couldn't hire appraisers directly because there was some fraud going on with other companies between builders and banks and appraisers and just crazy stuff. So basically the main thing that happened to our company as a result was that we had to actually start applying through, or we had to actually start advertising through platforms, and the platforms dictated our fees. So we no longer had control over how much we charged. It was, if we wanted the work, we had to take what they gave us. And so it got really crazy with, we took a pretty significant hit from that. That appraisal office, I am proud to say, is still going. And I talk to them a lot, but they're still going. They're doing great. They made it through, and they're doing great. But I left during that time only because I was trying to save the owner from my salary, because it was a little too much. So a little too much for him to handle. So I left during that time to help him out. He was very upset with me, but he got over it. He understood what I was doing. So anyway, there are situations where you would have a lawsuit that's just kind of thrown at everybody to see what sticks. And that happens a lot in lawsuits, and especially when the person that it's going to stick with is most likely going to be the one that doesn't have a lot of money or a lot of assets to fulfill that lawsuit. So they're going to go after all the big guns as well, so that they can try and get as much money as they can. So in this case, what do you think are the reasons that Fraioli decided to operate his business as a corporation instead of a sole proprietorship? Because it's only him as a shareholder.
Yeah, so he didn't lose all his assets.
Yeah, the liability, right? He didn't want the liability, personal liability.
Personal
So he put it back on the corporation. So do you think it was ethical for Fraioli to assert the corporate shield to avoid liability in this case?
No.
You don't think it was? Because he's already going to have some sort of liability on the corporation side. So do you think he should have had liability on his side as well?
No.
No.
Okay. Yeah, so I mean, what that did is it protected him as an owner, but the corporation was still most likely liable. And it doesn't tell about the case with the corporation. It only goes over the case with Fraioli. And yeah, Fraioli. So the corporate shield that they're talking about, we'll kind of talk about that a little bit more. So if you think about this, and a shield is a good word for it, but basically, if you think about this as an owner, if I have a corporation, I'm shielding myself and I'm keeping myself out of the corporation and away from that liability, even though I'm still running a business and I'm still taking care of the things that need to be taken care of. So it's really a good thing to have that corporation protection if you can. And there are a lot of stipulations that go along with having a corporation. There's a lot of work involved in having a corporation. The process is way crazier. But to form a corporation, you'd register it with the Arizona Corporation Commission, like we talked about before. You would have to choose what kind of corporation you wanted to have. There are lots of types, such as private, publicly held, nonprofit, government owned. And a corporation is domestic to its state. So if I registered my business, my corporation with Arizona, then if I went into Nevada, I would be considered a foreign business, a foreign corporation. If I went to wow, I just blanked, to Europe, and I went over there, I would be considered an alien corporation. So there are different designations depending on where you were actually incorporated at. And that plays a huge part too, which we'll talk about a little later. So you have to do, like I said, a lot of steps to become a corporation. And one of the first things that you have to do is you have to select a name. You have to select a name for your corporation, and you have to do it within the certain parameters. You need to keep in mind, you have to use corporation, wait, what is it? It's corporation, company, incorporated, or limited in your name. So if we look at the case with Walmart, you notice, I'm trying to find it now. Or, oh, there's Bank of America. Walmart Stores Inc. That's their name. So they had to use Inc., which is the abbreviation of incorporated, right? So if you don't use the actual incorporated or the actual word, then you would have to use an abbreviation of those words. The name must not contain words or phrases that are not part of the corporation's purpose. So for example, Walmart couldn't say, I am Walmart Bank, because they're not a bank. But they can say they're Walmart stores because they are a store, right? So you have to keep that in mind. And then you also have to check the name to make sure that it's available. It's not in use already. Make sure that it's unique and available. So from a digital perspective, you should also consider the domain name. Because if I go to walmart.com, I know exactly where I'm going, right? So I would want to make sure that the domain that applies to my name is available. And a lot of corporations have several domain names, depending on what they do. And that's fine too, but you would want to check your domain name and see if it is available for you. So you also have to submit, when you're applying for a corporation, you have to submit articles of incorporation, corporate bylaws, and meeting minutes from the organizational meeting of the board of directors. So let's take a look at those. They are in your book. In my book, they're on page 517, 519, and 520. And they're little yellow boxes.
587.
587?
585 to 587.
Okay. So if you take a look at the first one, it's the Articles of Incorporation. So in this, what it does is it says, and I love that they use the Big Cheese Corporation. It says that this is the name. And then it says the purpose of this corporation is to do this. Then it says the name and address of the corporation is this. And then it says that this is how many shares we have as a corporation. Then it says these are the people that are our shareholders. These are the people that are appointed to act as directors of the corporation. And then it says the liability of the directors of the corporation from monetary damages shall be eliminated to the fullest extent, blah, blah, blah. So it talks about that. And then it talks about the agents. And then it says the undersigned, being all persons named above and the initial directors, have executed these articles of incorporation dated blah, blah, blah. So anyway, this is a copy of an articles of incorporation. If you were going to do, you can absolutely do these yourself. However, if you were going to start a corporation, I would really, really, really recommend that you go to a lawyer and have them help you. There are actually, and you don't have to even go to a lawyer, you can go to someone that does these. There's actually people in lawyers' offices that do just this. So you're not actually getting that lawyer fee, but you're getting the fee of their professional, and you're still getting that professional documentation. So the next one is the bylaws. And in the bylaws, it's going to basically talk about what rules they have for starting this business. So, for example, they're talking about the annual meetings and if they have any special meetings and a quorum and what makes up a quorum. And other offices, principal executive office. So they're just talking about all the different offices and how the shareholders are treated and how the directors are treated. And that's what the bylaws do. And I apologize. I'm going to mute you. If you could please take a look at the minutes of the first meeting, and I'll be right back. Okay, so these meetings, or I'm sorry, these minutes for this first meeting, they talk about all the things that you would need to organize the business. So, for example, I'm so sorry. Can you guys hear my dogs?
Yeah, it's okay.
Oh, okay, good. I'll just leave it. All right, so for example, they talk about the stock certificates in here, how their officers are elected, how the bylaws were adopted, how the articles about corporation were put together, all of that. So that talks about all of that. And all of these things have to be filed when you file your corporation. So when you go to Arizona Corporation Commission and you file your corporation, if that's where you do it, then you would have to file all those things as well. And these documents also are really great for establishing the business. So they're really good jump off boards for how your business is going to look and how it's going to run and all of that. So, so as you may have noticed, the articles of incorporation state how many shares of stock the business is authorized to issue. So that was on number 4. It said this corporation is authorized to issue only one class of shares, which will be designated common stock. The total number of shares it is authorized to issue is 1 million shares. So that's what they have available. Shares are something they have to keep track of and they have to take care of in that regard. So let's see. So common stock is the equity that represents the residual value of the corporation. Common stockholders have the right to vote on important matters, and they receive dividends in return for their investment. Preferred stock is the equity that has certain preferences and rights over common stock. Essentially, they are given preference and would be paid out before common stockholders. The specific preferences and rights that preferred stockholders would be set forth in the articles of incorporation. So in this case, they didn't have any preferred, they only had common stock, so they didn't have anything set forth in the articles of incorporation about how the preferred stock would be handled. Corporations that are separate entities, and that means they're taxed on their own. You asked a question earlier, Vanessa. Did I answer it?
Well, yes, but, does it cost more for a corporation to have common stock over preferred stock, or how does that? Is that
It's-
something that the corporation pays for, or how does that work?
So preferred, and we're going to talk a little more about preferred stock. I think we are, thought we were. So preferred stock, let's talk a little bit more about that. So preferred stock, basically you're going to have something set up that says if you do preferred stock, then these are your rights. This is what your preference is, and this is how it's taken care of. So you would have possibly a dividend preference. So that's the right to receive a fixed dividend at set periods during the year. So maybe quarterly they pay their dividends out to their preferred members. Liquidation preferences. So if the business is ever liquidated, you have preference over the common stockholders. If you have a cumulative dividend right, that's when a corporation must pay any dividends. So if they didn't get to the number that they needed to have for that dividend, they have to pay the back pay, or whatever you want to call it. If it's non-cumulative, then that's not something they have to worry about. And then they have the right to participate in profits and conversion rights. So it depends on what is actually set forth in the articles of incorporation on what they'll actually have available to them. But if, and how it's set up. So it doesn't necessarily mean that the business is it's going to cost the business more money. I mean, it might, if you look at it from one point or another, but the reason that they would want to have those preferred stock members is to gain an additional amount of money or have additional capital infused into the business. So preferred stock is going to probably cost more than common stock, those kinds of things. And
They're gonna be more of like the heavy hitters.
yeah, and you're going to have, it's kind of like, if you kind of think of it as a partnership, you think of the partners and then the limited partners. So you've got the common stock and then the limited, limited stock, or the preferred stock.
Oh.
So
Okay.
kind of like that. Does that help?
Yeah.
Okay.
Yeah.
So let's really quickly talk about the S corporation. So I talked to you a little bit about this when I was talking about the PPP stuff, but so there's two types of corporations. There's the C Corp and there's the S Corp. So a corporation, like I said before, is a separate entity, and that means they're taxed on their own. But stockholders are taxed on the dividends they receive. So if you look at that, you're being taxed and then you're being taxed again. So as a sole proprietorship, if I was a sole proprietorship, I would only be taxed once because it comes to me and I get taxed as an individual. So all those revenues, I'm only taxed once. Whereas a corporation, you're taxed and then you get taxed again. You get taxed again at an individual level for your share. Andrea is asking a question. Are you in business accounting? So they do talk more about common and preferred stock in that class, right, Andrea?
Yeah, that's why I was wondering if she was asking those questions.
Okay.
I'm actually at 256.
So you've already taken it and, yeah.
Yeah, I didn't know how it works like with a corporation. Like, are those stocks like assigned? Do you choose those stocks? Like, how does stocks come about within your company? Is it
Right.
something that you create, or is it based on like collectiveness of people that create the company, so to speak?
So you do create a corporation, it would create those in a sense, but they're limited, and things are limited based on how they were incorporated. So they have limitations, and they have to be very careful about that kind of stuff.
And then they decide how many shares they're gonna offer. Right?
Yeah.
Mhm.
So so to alleviate the situation of having that double taxation where the business is taxed and then the shareholder is taxed, the S corporation became a corporation type. And the S corporation is only for smaller corporations. So you cannot have more than 100 shareholders if you're an S corporation. And there's some other stipulations as well. But if you file, file for S corporation, then you would, if you file for S corporation, then you would have, if you were approved for that, then you would have basically all of the taxes would be pushed down to the shareholders' tax returns, and it would only be taxed once. So that's the benefit of an S corp. So when you're incorporating, you are going to want to think about the laws that govern you and how they're different. Because when you incorporate in Arizona, you're governed by the state laws in Arizona for corporations. So there are some states that have favorable situations for corporations. One of them is Delaware, and it talks a little bit about this in your book, but Delaware has laws that corporations can, that can help the corporations avoid hostile takeovers. They've got like an anti-takeover rule that helps them avoid anything that they don't want to do. Special courts that hear their cases and a bunch of stuff like that. There are other states like Nevada that do similar types of things. So Nevada does not have sales tax. That's what makes it desirable. A corporation doesn't want to deal with, or I'm sorry, they don't have state tax, not sales tax, sorry. They don't have state tax. So that's very desirable for a lot of corporations because they're only paying at the federal level and not at the state level. And it can save them a lot of money. So incorporating in Nevada is a fairly simple process. And why do you think these states would want to cater to a corporation?
Because it keeps money in state.
Yeah, that's right. But also,
And jobs.
What was that, Andrea?
And jobs.
And jobs, yeah, good. And also, so when you incorporate, you're going to pay a fee to the state to incorporate with them. So, for example, if I were a corporation, I don't know what the fees are actually. I'm sorry, you guys, but there are fees involved. So let's say that they're $350. I know they're more than that, but let's say that they're $350 to incorporate. So you would have to pay that $350 to the state for them to process your paperwork to become a corporation. And you would pay that yearly, most likely, in most cases. So those states take that money, they use that money, right? That's money that's infused into the state. So not only the jobs, not only the revenue that's coming in, but also they're making a ton of money off of these corporations that incorporate with them. That's why they want to make a favorable situation for those corporations to come in and do business in their state. All right. Chapter 28. This talks a little more about corporate governance, and Sarbanes-Oxley, which we've talked about a little bit before in the past. So a corporation has a ton of moving parts, right? So everyone has their responsibilities, and shareholders are the owners of the company. But they're not agents and they can't enter into contracts. They can vote on certain matters, but they can't actually enter into a contract on behalf of the company. The board of directors is elected by the shareholders. The board is responsible for formulating the policies and policy decisions that affect various operational controls of the corporation. And the board of directors is also responsible for appointing the corporate officers. And the corporate officers are authorized to appoint assistant officers. And those officers are responsible for the day-to-day operations of the corporation, and they are considered agents of the corporation. So they can actually enter into contracts on the business's behalf. So kind of a different situation, right? And this is why you would want to make sure that those officers that are hired for that position are good, trustworthy officers, right? So officers and directors owe a duty of care to the corporation. So they should act in the best interest of the corporation at all times. And we are human and we can make mistakes. We talked about that a little bit more. And so there is a safeguard called the business judgment rule that states that if an officer or director makes an honest mistake, they are not liable for that decision. Officers and directors also owe a duty of loyalty to the corporation, meaning that they should put the interests of the corporation above their own. So they need to think about the business first and then themselves. Let's take a look at 28.2 on page 542 in my book. And this is McPadden versus Sidhu. And this talks about the fiduciary duties of the corporate directors.
510.
Thank you.
Man, this guy really did a number.
Yeah, he did. So this is what I was talking about on how,
He drove the company's value down intentionally so he could buy it himself. Why would they put him in charge of finding a buyer if they knew he was interested in buying?
why would they put him in charge at all if his character is this, right? Because in a business, you want to make sure that the people that are running your business for you, which in this case are the officers, they're running the business, they're making the business decisions. You want to make sure that they have the best interest of the business, right? You want to make sure that they're not doing something in their own interest, which is what he was doing. So
Right.
basically, he took it and, sorry, go ahead.
And under his leadership, the company it lost profits, right?
Yes, he drove them down. So
Exactly.
he made it happen that way so that that would be, so devalued the company, basically.
Correct.
He devalued the company so that he could actually sell it and buy it himself, because the group was
could they
led
not
by
sell this-
him. It was formed by someone else, but it was led by him, it looks like.
It seems like a company would have internal controls to prevent a situation like this.
And if they didn't at that time, they absolutely do now, don't they?
That's right.
We learn from our mistakes for sure. So do you think he acted unethically in this case?
Absolutely.
Yes. Did the directors act unethically in this case? So the directors were, well, let's talk about it's all unethical. So let's talk about what purpose does Delaware's law that relieves directors from personal liability for their ordinary and gross negligence serve? So this law, it actually is there to protect from people like this, from the officers that don't act in the best interest of the company. All right. So we talked about that corporate shield earlier, and I want to talk now about corporate veil. So there's a saying, have you guys heard it, called piercing the corporate veil? Okay. Do you guys know what that means?
No.
Somewhat? Okay.
No.
So like we talked about before, every business should be, or every corporation, well, actually, every business should be treated as a separate entity, even if it's not. So if I were a sole proprietorship, and this is coming from an accounting person. So if I were a sole proprietorship, I would not want to have, I would not want to put the money from my business in my personal bank account. Why?
Because then it's up for grabs.
What if I get audited? Now I have to supply not only my personal statement or my business stuff, but I also have to show my personal stuff. So you want to keep it all separate. And in a corporation, it's even more important that stuff is separated, right? So funds for a business should never be held in a personal bank account. It happens all the time, I'm telling you right now, but it shouldn't happen. So the funds should be kept separately. And this is even more important in a corporation, and they are a separate entity, and commingling those funds is actually not allowed. So you should never commingle those funds in a corporation, because there is that shield. And by commingling, you are actually, we'll say it's a veil. So if I had a veil on and I commingled the funds, I'm taking my personal and I'm sticking it through that veil, or piercing the corporate veil into the corporate's information. So now my personal and the corporate's information is all commingled. It's all just not right anymore, right? So it's not a separate entity. I'm not treating it as a separate entity. So that's what that's talking about. And piercing the corporate veil is a term used to hold the shareholder personally liable if they use the corporation for improper purposes. So let's take a look at the case on page, or I'm sorry, case 28.1. This is Northeast Iowa Ethanol LLC versus Drizzen. And in my book, it's on page 535.
503.
Thank you.
Yay, justice prevailed.
All right. So here is
pun
quite the
intended.
case, right? There's a lot of stuff going on in here.
Yes.
So this guy, this Drizzen guy, is pretty crazy. He took $3 million some odd dollars from Northeast Iowa Ethanol LLC and said, hey, you know what? I can take this money and I can get you the $20 million more that you need. And so he said, but you have to put all this money into my business's account. And then he transferred that money into his personal account. He put it in different frivolous or fictitious, I should say, investment opportunities and all this to try and make that money. And instead, he was just basically draining their account. So he took the $3 million and ran, basically. So, so in this case, like Andrea said, was it Andrea that said it? That said that, oh, justice prevails?
Yes, yes, it was.
So the U.S. District Court held that the corporate veil of GSI could be pierced to reach its shareholder, Drizzen, because what did he already do? He already pierced it, right?
Yes.
Yeah, by putting that money in his personal account.
Personal account.
Mm-hmm. Yeah. So there is no longer a shield and that veil can be pierced. So now he can be held liable. And so do you think he acted ethically in this case? What a
No.
question, right? Absolutely not. So did the owners of Northeast Iowa have any responsibility for the losses they suffered in this case?
I would think not.
No.
So I would say no.
No.
But
Well, they did make the decision to put all their money in this guy's account.
yeah, and did they do their due diligence? Did they check him out?
Apparently
Did they put any policies in place to have him go through them before he did any investments? Those kinds of things. So they didn't. There's possible liability for them there because they didn't, you know, put those things in place. Do you think that if they ever did anything again, do you think that they put those things in place after that?
Yeah.
or said, no, we'll do it ourselves.
Right?
So it's, it's human nature. We want to trust people, and it's unfortunate sometimes it just doesn't work out the way we want it to. So we've already talked a little bit about the Sarbanes-Oxley Act, and how it affects everything, but the corporate governance. So this act plays a major part in corporations. So it came about as a result of accounting and business scandals that were committed by major corporations. And we're talking, let's see. We're talking corporations like Enron and Tyco and WorldCom